Do you know what happens when a public officer refuses to perform his legal duty? That's where the writ of mandamus comes in. The word mandamus is Latin for we command. It's issued by the Supreme Court or High Court under Articles 32 and 226 of the Constitution, commanding a public authority, government officer, tribunal, or lower court to perform a duty they are legally bound to do, but have failed or refused to perform. In simple terms, it's the court telling an authority, do your duty, as the law commands. The writ ensures accountability, good governance, and rule of law. For example, if a government officer refuses to grant you a license, pension, or knock even after fulfilling all legal requirements, the court can issue a mandamus directing them to act. However, there are limits. Mandamus cannot be issued against the president or governors for their constitutional duties, it cannot be issued against private individuals, and it also doesn't apply where there is no legal duty involved. Now, let's look at some important cases. 1. Gujarat State Financial Corporation vs. Lotus Hotels, 1983, the court held that a public corporation cannot escape from its lawful promise, the court can compel performance through mandamus. 2. Praga Tools Corporation vs. CA Manual, 1969, the Supreme Court clarified that mandamus can be issued only against a body performing public duty, not a private company. 3. Controller and Auditor General of India vs. KS Jogannathan, 1986, the court said mandamus can compel not only action, but also proper and fair exercise of discretion by public authorities. So, in essence, mandamus is the voice of the law commanding the state to act justly, fairly, and responsibly. It ensures that no authority in India can ignore its lawful duty or misuse public power. Follow for more such updates.